Hey, it's 11:01. Good morning, everyone. Thank you very much for joining us today. My name is Andrew Tobin, a partner specializing in insurance and reinsurance at Mills and Reeve. Today, we're going to be looking at litigating coverage disputes, insurance coverage disputes in the USA and England, and asking what the differences are. I'm delighted to co-present today with Stephen Clancy from our network firm, Robinson and Cole in the USA. Stephen is a partner and insurance specialist at Robinson Cole's Hartford, Connecticut office. And it's 6 o'clock in the morning there. So thank you very much, Steve, for joining us. Because there are two of us talking today, this session is going to be a bit longer than our regular cover talks. So in the next 35 minutes or so, we're going to discuss just some of the differences between England and the US when litigating commercial insurance coverage disputes at a high level. And I think this is an important topic for anyone that is used to handling claims arising in the US and or in England, because although outwardly there are many similarities between our systems, such as language, concepts, legal traditions, in fact, there are very many significant differences. And also bearing in mind that US law governed risks probably account for more than 50% of those risks written in the London insurance market, and that our case handler clients often handle both US and English and other matters. This outward similarity but substantive difference leads to a huge amount of confusion in practice, because, for example, people who are familiar with US practices will often mistakenly imagine that English courts will follow a similar approach, and vice versa. And that can lead to quite a lot of misunderstandings tactically and strategically. Our presentation is one way. We can't see you, but you can see us. After we've spoken for about 35 minutes, we'll take a few questions. As we go along, please put your questions into the question and answer box, where my colleague Harriet Strevens will curate them for us to answer at the end. A copy of the recording will be circulated afterwards. We've got a few slides, but they won't be in any particular detail today. But first of all, let me hand over to Steve Clancy. Steve, would you be so kind as to introduce yourself and your firm?
Certainly. Good morning. Thank you, Andrew. As you mentioned, my name is Stephen Clancy. I'm a partner in the insurance and reinsurance practice group of Robinson & Cole. Robinson & Cole is a Am Law 200 law firm in the U.S. with a proud 175-year history. Our insurance coverage litigation team features more than 50 lawyers operating in offices in 7 states along the U.S. East Coast. Our practice focuses on coverage advice as well as first-party insurance coverage and extra-contractual litigation in state and federal courts throughout the United States. It's national in scale and encompasses various lines of coverage, including commercial property, complex CGL, and financial lines. Very happy to be here with everyone this morning.
Thank you, Steve. May we have the agenda slide? So today we're going to touch on some of the following topics: jurisdiction and sources of law, appointment of judges, jury trials, policy construction, evidence and depositions, costs, punitive damages, and bad faith. Obviously, in the time available, we've had to pick just a handful of topics to look at a high level, but we'll try to draw out some key themes. So first of all, I wanted to discuss concepts of jurisdiction and choice of law. So on this side of the pond, we have a single United Kingdom, which consists of only 3 internal sub-jurisdictions. We've got England and Wales. That's a single jurisdiction where 85% of our population live. We have Scotland and Northern Ireland. And each jurisdiction has its own court system, its own legal profession and traditions, and we don't have any overarching federal jurisdiction or indeed a written constitution. Rather, we have a sovereign UK Parliament that has unlimited powers to legislate in any way it wishes for any part of the UK. And we have local parliaments and administrations in Scotland, Northern Ireland and Wales that can exercise powers delegated to them from the UK Parliament in Westminster. That said, in practice, the insurance common law is virtually identical throughout the UK, and the same insurance statutes and regulations apply equally throughout the UK, more or less. And the ultimate appeal court from all parts of the UK on civil matters, including on insurance coverage disputes, is the UK Supreme Court. So when it comes to insurance law, in practice, whichever part of the UK one is in, we're all looking at a single body of law, cases, textbooks, and so on. There's a further special feature of English law to bear in mind, which is that it's probably the predominant legal system chosen by parties globally to govern their contracts in trade, finance, and insurance. So, and moreover, the vast majority of risks written in the Lloyd's and London insurance market are overseas risks. So the commercial court division of the High Court in London deals with large domestic insurance disputes, but probably the majority of its work is international in nature, and that reflects the work that that we do here as well. But Steve, perhaps you'd like to talk about the position in the States.
Sure. So we I guess tend to overcomplicate things. The U.S. system can be broken down generally into the state court system and a federal court system. In the state court system, you're dealing with essentially 50 individual jurisdictions, each of which will have their own jurisprudence, their own rules of practice, regulatory law, and statutory law. So as a result, a policy provision that might be enforceable in one jurisdiction may not be in another. For example, in the property insurance context, anti-concurrent causation language would be enforceable in the vast majority of states. However, I believe at least 4 states, I think Washington, West Virginia, California, and North Dakota, prevent enforcement of that language. And similarly, the majority of jurisdictions would give effect to a choice of law or mandatory arbitration provision, but a few states disallow enforcement of mandatory arbitration provisions in insurance policies. So you can get a lot of variation because you have a lot of different jurisdictions and different rules that you're dealing with. Structurally, each state court system typically consists of trial courts, sometimes referred to as circuit or district courts, intermediate appellate courts, although not all states have those, and then a court of last resort, typically referred to as a Supreme Court. But to make things confusing, in New York State, we call the trial court Supreme Court. Running somewhat parallel to the state court system, you have the federal court system, which consists of 94 district courts, typically 1 or more per state, 13 geographically placed circuit courts of appeals, and then the United States Supreme Court. The federal court system, again, will have its own jurisprudence, its own rules of civil procedure and evidence. In addition, the district courts, so the trial court levels, will often have their own local rules, and individual judges will then have their own chambers rules. So we I guess tend to like a lot of rules. The primary difference between the state and the federal courts for civil cases is the type of cases that can be heard in the federal system. The federal courts are courts of limited jurisdiction, meaning that they can only hear cases authorized by the U.S. Constitution and the federal court system, and the federal statutes. So insurance coverage actions that end up in a federal court have typically gotten there on the basis of diversity jurisdiction. And diversity jurisdiction allows a plaintiff in one state to file a lawsuit in federal court when a defendant is located in a different state and the amount of controversy exceeds $75,000. Defendant can also remove a matter that's been filed in state court on the basis of diversity jurisdiction. If you're going to see a coverage dispute in federal court, it's often going to be based on that jurisdiction. As far as where's the better place to end up, I have many clients whose initial reaction is to remove any case that's removable to federal court. They believe that stronger judges, better chance on a motion for summary judgment there. Certainly there are benefits to being in federal court. There are quality of justice, judges, consistency of rules. I think typically in federal court, probably the case life is a little bit shorter. They move things along a little quicker. That said, I believe there are good judges and good outcomes available in both systems, but really key to know the venues and the potential judges, which I think is what we're going to get into next.
Thank you, Steve. It's a pretty complex and rich picture. Moving on next to the appointment of judges. So over here, we talk about High Court judges who deal with the most substantive cases. They're appointed in theory by a government minister on behalf of the Crown, but in practice they're appointed after an open competition run by the Judicial Appointments Commission, which is an independent technocratic committee consisting of senior lawyers and judges. And politics don't usually come into it. Our High Court judges tend to be very experienced commercial barristers from the very top of the profession. It's a very elitist system, but considered by many to produce very high quality and independent judges, qualities which are essential to making London a leading destination for the resolution of international commercial disputes. Steve, what can you tell us about the position in the States?
Yeah, so again, a little more variety in how judges are selected. In the U.S. federal court system, judges are nominated by the president, confirmed by the Senate. They typically hold office then for life, absent some form of scandal or controversy. They can be removed through a congressional impeachment proceeding, but it's rare. State court judges are selected in a variety of ways depending on local state rules. So they can be via election, via appointment to a certain number of years, a term, appointment for life, or some combination of those methods. So for example, in the state where I reside in Connecticut, there's a judicial selection commission, and that recommends to our governor qualified individuals for nomination as judges. The governor will then choose the candidates from that list. He'll refer those candidates to the General Assembly's Judiciary Committee for confirmation and public hearing, and then they need to be approved by both sides of the legislature. So a little bit more of a extended process there. And then you mentioned politics not being a part of the process in the UK. While there's checks and balances in place here, increasingly, I think the appointment process can become somewhat political in the US, especially when one party happens to control the executive and legislative bodies necessary to appoint and confirm judges. And we've seen that certainly on the federal court level and at the highest levels in recent years. As for the election process for judges, well, that's overtly political. These individuals are running for public office, and once in office, they're running for re-election. So obviously some politics can factor in there. One other note on judges in the States, both federal and or state court judges are typically going to be generalists. So there's not going to be insurance coverage specific judges. That said, many state court systems have established complex litigation dockets or commercial dockets where larger coverage disputes will end up. Also, there's occasions where you'll see a docket established in the federal state courts specifically to address a mass insurance event. For example, Superstorm Sandy created their own dockets in various locations, and Chinese drywall, which was an issue for years, created their own dockets in certain locations. So you had instances where judges were handling a large amount of insurance coverage matters and would gain specialized knowledge as a result of that. But as a general matter, there's not an insurance-specific judge you can go to.
Thank you, Steve. Again, a very complex picture compared to ours. Turning to jury trials. So in England, the judge decides everything in nearly all civil matters, including in insurance. He or she determines what the law is. They listen to the evidence and decide what the facts are, and they decide essentially who wins or loses the case. Juries, we used to have juries in civil cases, but they were abolished for all practical purposes a long time ago. And insurance coverage disputes in court here tend to be pretty dry and technical. They would make really terrible television, I'm afraid. Now, also, judges here in commercial matters, they don't lean one way or another. You can't say they lean in favor of insurers or insured. On the whole, the approach is neutral, intellectual, and technical. But Steve, the positions are a little different over there. Perhaps you'd like to talk to that.
Sure. So in the States, we have both jury trials and bench trials. During bench trials, the judge will decide everything more similar to your model. During jury trials, the judge will determine what information may be presented by making evidentiary rulings and rulings on objections. At the close of evidence, the judge will then also instruct the jury in the law to be applied. So that can pertain to policy interpretation, burden of proof, bad faith. And you also instruct the jury in the specific decisions that they need to make. It's then to the jury to find the facts in the case based on what was presented and apply those facts to the law as instructed by the judge and rendering their verdict. So a little bit of a dual role there. I did want to just touch briefly on jury selection or voir dire, because that can vary greatly depending on what jurisdiction you're in, and it's also can be just critical to a case. Jury selection in the federal court system generally follows a procedure where the court randomly selects and summons a pool of prospective jurors, typically from voter lists or driver's license lists, and calls them in for a specific date or specific case. The judge presiding over the case then determines which jurors should be excused for hardship. And after that, the attorneys or the court, depending on local rules or the judge's rules, will begin questioning prospective jurors, usually in groups. And then they will either select jurors, exclude jurors for cause, or use a peremptory challenge to remove a juror for any reason, potential juror for any reason. The state court selection process can be similar to that, but there are states that conduct it very differently. For example, using Connecticut as an example again, selecting a jury here involves individual voir dire. So the parties get an opportunity to question each potential juror separately. It's almost a short deposition of each potential juror. So the defense counsel, the coverage counsel will be in the room, policyholders counsel will be in the room with just the potential juror. Oftentimes the judge is not present for that. And they'll have opportunity to question the juror on their background, on their thoughts generally about the insurance industry for coverage cases. So it allows you to get a much better sense of your jury panel, to get to know your jury panel much better in advance before making decisions on who you're going to select and who you're going to eliminate. It also makes the process obviously much more time consuming and expensive because you're going through each person individually. And it can take over a week to select a jury in a very simple case. So, I think big picture, you're critical to understand your venue and your potential jury pool. So before deciding whether to claim a matter to a jury, proceed to a bench trial, we're having discussions with our clients regarding what that jury pool looks like, the makeup of that jury pool, conducting jury verdict research to try to determine how similar matters have been handled, how verdicts have come down. Seldom do I have an insurance coverage case where a judge doesn't say to me at some point, typically in a settlement discussion or as we approach trial, that, well, juries don't like insurance companies. Everyone on a jury panel is uninsured in some capacity. So you got to assume that there's a natural tendency for them to identify with the policyholder. Also, many times potential jurors have gone through a claim process at some point in their life at some level, in some capacity, and may not have had the best experience. That being said, however, there are plenty of communities where the insurance industry is a large employer and potential jurors have friends, neighbors, spouses, relatives within the industry. And so they're not going to harbor any ill will towards insurance companies. All that being said, I think it's critical for insurers to understand the venue and the jury pool they're walking into and to utilize voir dire in order to eliminate as many potentially bad jurors as possible and select the ones that are going to give you the best chance to success at trial. If you do, just as a last point, if you do find yourself in a situation where a jury has come back with a crazy number, a runaway verdict type of situation, there are mechanisms to challenge that in the states. In addition to appeals, obviously, a party can seek a remittitor, which is a motion seeking to have the damages awarded by the jury reduced. It's a tough standard, as damages have to be grossly excessive or shock the conscience of the court. So it's not granted often, but there are opportunities to challenge that. Where we see that most often is our clients will come to us having been after an excessive verdict has occurred. Now you have an insured claiming bad faith failure to settle on behalf of the insurance company, saying, well, you could have resolved this within limits during the underlying case. He chose not to. We went to trial. We lost. We now have this huge excess verdict. We now think it's bad faith on the way you handled it underneath. So, we can often get involved at that point to try to navigate that situation. But it can be a difficult road later on if you don't have that jury pool and jury selection process done well in the first instance.
Thank you, Steve. That's fascinating. Personally, I'm relieved that I don't have to worry about the views of individual jurors over here, but maybe your system is more exciting than ours. So turning to construction of policy language. So insurance coverage disputes inevitably involve a lot of scrutiny of policies, words, phrases, and so on. We could spend weeks talking about them, but I thought we'd just try and explore some very, very high level differences. So in England, commercial disputes, and leaving aside consumer matters, it's for the judge to decide what words mean in light of their ordinary meaning or technical meanings where appropriate, or case law, if there is any. And the overall process has been described by our highest court as the ascertaining of the meaning which a document would convey to a reasonable person having all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time of the contract. And the courts will also bear in mind the commercial object or purpose of the contract and the purpose or function of any clause. And recently they emphasized that if detailed and semantic analysis of words in a commercial contract is going to lead to a conclusion that flouts business common sense, then it must be made to yield to business common sense. But none of that necessarily means that the English courts lean in favor of insureds, because what is business common sense, has to be business common sense objectively looked at, and the interests of both parties are relevant. So properly drafted exclusions, conditions precedent, and so on can all have legitimate commercial objects. They can all make business common sense and are assessed objectively by the courts in light of case law. And over the centuries, the courts have been mindful not just to favour insureds, but to balance that with the interests of insurers who have been central to the prosperity of the City of London. So English rules of construction are not designed to favour either the insured or the insurer, at least in commercial disputes. And so it's often dangerous under English law for commercial insureds to imagine that a court is going to give them the benefit of the doubt when it comes to interpreting contracts. Steve, what's the position over there?
Yeah, so the general rules for policy interpretation are similar from the state and the federal courts, and similar to what you just described. I don't think they're intended to favor a policyholder. I think they're intended to really give effect to the contract as written. So the interpretation of insurance policies here, like any other contract, involves a determination of the intent of the parties as expressed by the clear language of the policy. So words in the policy are going to be given their plain and ordinary meaning, unless it's obvious that a technical meaning was intended or unless a term was defined in the policy. However, where there's no ambiguity in the policy and only one reasonable interpretation is possible, that's what the court will give effect to. The plain and ordinary meaning without resorting to other rules of construction. When you have an ambiguity in the insurance policy, that's where it must be construed in favor of the insured. So if there's an ambiguity, that's going to be construed in favor of the insured. But the fact that parties advocate different meanings of the words in the policy does not by itself establish an ambiguity. The policy language is ambiguous only if reasonable minds could differ as to the meaning of the term. So the policyholder's expectations should be protected as long as it's an objectively reasonable expectation from a layman's point of view. Moreover, the provisions of the policy aren't going to be construed in a vacuum. They're going to be construed from the perspective of a reasonable layperson in the position of the policyholder of the policy, purchaser of the policy, rather.
Okay, so again, we've got similarities and differences. On the contra proferentum point, we have the same concept in theory over here, but I would say that in recent years, the English courts have become much less attached to it, and is very much a rule used as a last resort. And again, it would be a mistake for insureds to assume it will come to their assistance. And another perhaps difference in detail for London market practice here, the basis of the rule is that genuine ambiguity will be construed against the drafter of the document. But in the London market, very often the broker who is the agent of the insured is the drafter of the slip and the policy wording. So the rule often doesn't come to the assistance of the insured in that context. Turning to, we've just got a couple more topics to come to: evidence and trial costs, and then punitive damages and bad faith. So 3 more topics. In England, the trial process is basically as follows: a claim is served, the defendant files a defence, the court lays down a timetable for disclosure of documents and for the exchange of witness statements for those witnesses that are intended to give evidence at trial, and eventually the matter is set down for a hearing date. Either side can try and truncate the process at an early stage before disclosure by applying for summary judgment on the ground that its opponent's case or part of its case has got no reasonable prospect of success. But the witness statements I mentioned are each witness's evidence in chief. They're signed by a statement of truth, and that's what they will be cross-examined on at any eventual trial. And the evidence tends to focus here on the circumstances of the loss and expert evidence if necessary. This is in a coverage dispute. It's very rare for claims handlers to give evidence on coverage disputes because usually their evidence is irrelevant to the construction of the policy or the circumstances of the loss. But in contrast, many claims handlers over here in the London market live in terror of being deposed in US proceedings, or alternatively, when they have been deposed in US proceedings, wear that as a badge of honour. But Steve, perhaps could you shed a bit of light on what depositions are? And
certainly. So depositions are a critical part of our pretrial discovery process. We have basically 4 main pretrial discovery mechanisms for obtaining evidence from other parties or third parties, and they are interrogatories, which are written requests for information, requests for production, which are written requests for documents, requests for admissions, written requests to have someone admit a fact, and then depositions. The deposition is either you're going to be put under oath, there'll be a court reporter present, you'll be questioned by opposing counsel, your attorney will be there and will be able to object where appropriate and also question you if they need to clarify or correct anything. In coverage matters, policyholder counsel are typically seeking to depose the claim handler or a corporate representative of the company to evaluate the claim handling or to gather information regarding the company's history of handling similar claims. This is done in the hopes of gathering evidence to support a bad faith claim generally. Those types of claims can require an insured to demonstrate that the insurer's conduct was either motivated by a sinister or dishonest purpose, and on the common law bad faith claims, and on the statutory claims, they're often required to demonstrate that the insurer had a general business practice of the alleged misconduct. So that's why they're digging into some of that information in that depositions. Very important to remember, if you are deposed, that a deposition is much closer to an interrogation than it is to a conversation. So the opposing counsel is there with a purpose, and regardless of how friendly they may be acting, they have an agenda, and it's certainly not to help you or your company. They're trying to size you up as a witness. Will the jury like you? Will the jury trust you? They're trying to get certain things, most often just small sound bites that they would need to support their case or motion. So they don't want the full answer. They just want the portion of it that'll be helpful to them. Or they may simply be trying to dig into learn more about the claim handling or the company's history with similar claims. But we really preach and practice the importance of deposition preparation for insurance claim handlers and corporate reps, particularly people who haven't been through the process. Preparation has to be taken very seriously for these depositions. You should expect at the very least, a full day of preparation. That's after a fair amount of discussion, preparation, document review in advance of that full day preparation session. So, a claim handler, corporate representative deposition can really make or break a coverage case, particularly one that includes extra contractual claims. So there is no substitution for thorough preparation on that front. I would definitely stress that today.
Thank you, Steve. So turning to costs, in England, the general position is that a losing party to a coverage dispute will have to pay the majority of the winning party's costs. And costs can also be awarded as we go along through the case. So to a party that loses any particular application might have to pay the costs of the winning party's costs in that application. And for those reasons, parties tend to think very carefully about starting proceedings, defending proceedings, wrongly making or wrongly defending applications, because doing so, always carries this cost risk. And that cost risk is a theme that runs through all of our civil matters, and it strongly incentivizes parties in many cases to consider settling rather than fighting a case all the way until judgments. But Steve, what's the general position in the US?
In the United States, the party who pays the court costs is governed by the American rule, which provides each party bears their own cost for their own legal fees. The rule has exceptions whereby a prevailing party can be awarded attorney fees. Generally, those exceptions include the parties have a contract that has an agreement to that effect. There's a statute that allows the imposition of such fees. There's wrongful conduct of a defendant that forces a plaintiff into litigation with a third party, or a plaintiff is forced to defend against a malicious prosecution. Most jurisdictions have enacted statutes which prohibit unfair claims settlement practices. Those often include an allowance for attorney's fees for the successful party. So in the insurance coverage context, you usually see those claims attached to a coverage dispute. That would usually open up the door for a plaintiff to try to seek costs and attorney's fees if they're successful in that litigation. But as a general rule, because each party's absence of these circumstances would be bearing their own costs, you do see a lot more motion practice in the States. There's not the same concern of where that ultimately leads us on costs down the road.
Thank you, Steve. I mean, in practice, I think this cost rule actually creates very different litigation cultures in the US and in England.
That's right.
Between the US and in England. So our final topic is one that keeps insurers awake at night: bad faith, punitive damages, and so on. Now, much to the surprise of our American colleagues, English law does not allow an action by an insured against an insurer to recover punitive damages for consequential loss caused by an insurer's refusal to pay a valid claim. We don't have any tort of bad faith, nor are punitive damages awarded in coverage disputes. So if an insurer wrongly denies insurance coverage and the insured is entitled to recover the indemnity due under the policy, then, if an insurer wrongly denies coverage and an insured sues on it, then the insured is entitled to its indemnity under the policy, probably interest at a few points above the bank base rate, and it would expect to recover most of its costs from the insurer, and that traditionally was all it would get. However, the position has been modified slightly recently in that the Insurance Act of 2015 created a new remedy by applying into every contract of insurance a term that the insurer must pay sums due within a reasonable time. What's reasonable is not defined by the court. There are a list of factors the court should take into account: the type of insurance, the size and complexity of the case, and whether there were reasonable, even if ultimately wrong, reasons for denying a claim. And so far, there are no reported cases in which an insured has succeeded in obtaining these damages. But it's thought that any awards, when they're made, are likely to be relatively modest, and the damages that would flow from a breach of this implied term are compensatory in nature, so they're going to be modest. They're not punitive. So we need to see how that evolves through case law. But what's the position in the US, Steve?
Yeah, so here, insurance bad faith is a tort recognized. The bad faith claim creates a source of potential liability and recovery that's distinct and in addition from the breach of contracts claim. So beyond the policy limits. There are essentially two types of bad faith claims in the States. There are common law claims and statutory claims. The common law claims are predicated on the notion that every insurance policy contains an implied covenant of good faith and fair dealing, meaning that the parties to the insurance contract have an obligation to proceed in good faith and act fairly in carrying out their respective duties under the applicable law. That said, you don't see a sort of reverse bad faith as a cause of action very often in the States. It's mostly a one-way street towards the insurer, as opposed to being able to be used against an insured that maybe hasn't behaved himself or themselves properly. The standard for proving common law bad faith varies by jurisdiction. In some locations, you need to be able to demonstrate a sinister motive or dishonest purpose. Others look to see if the insurer unreasonably denied or delayed payment of a claim that they either knew about or recklessly disregarded the absence of a reasonable basis to deny or delay the payment of the claim. Insurer is not liable for bad faith simply because there's a disagreement as to the amount of a payout, or there's a reasonable, or they're conducting a reasonable investigation of the claim, and it causes the claim process to last longer than perhaps the insured likes. The insurance company is entitled to conduct their investigation. If a claim's fairly debatable, they're entitled to take their position on that. So it has to be more than just a disagreement, more than and then even just negligence on behalf of an insurance company. There's got to be that extra step towards some type of wrongful conduct. As noted earlier, the punitive or damages are generally unavailable for just a straight coverage action, breach of contract claim. But under a common law bad faith claim, they are recoverable, and it typically shows up as attorney fees and cost of suit. Statutory bad faith claims are made pursuant to jurisdiction-specific consumer protection statutes. Some states have enacted their own versions of these kinds of statutes, but most follow the Model Unfair Claim Settlement Practices Act. And these often require the insured, as I mentioned earlier, to demonstrate a general business practice of similar misconduct by the insurer in order to be able to recover. Damages there for the statutory claims can consist of the actual damages caused by the violation, attorney's fees, cost of suit, as well as punitive damages. Again, important thing to remember is that the damages for these bad faith claims are going to be in excess of the policy limits. So that's where there's concern as far as the practical considerations to keep in mind when dealing with bad faith claims, because the reality is, and increasingly, they're attached to virtually every coverage suit that we see in the U.S. at this point. So most times there's not much merit there, but you're going to have to deal with them in some capacity because they're going to be pled, both a common law and a statutory claim. Oftentimes we're able to strike those early in the process through motion practice, but some do get through. And when they do get past the motion practice stage, they have the ability to expand the scope of discovery, lead to burdensome discovery obligations for the insurer, because again, the insured's trying to demonstrate that there's a history or a general business practice of insurer misconduct. So you need to be able to dig into that information and the history in order to support that type of claim. So if these claims survive the motion stage, they're going to result in more burdensome discovery and drive up costs. They also have the ability to create potential class action exposure because they're looking at, well, how do you handle all these other policyholders? And they can create challenges to the attorney-client privilege or other privileges if counsel was involved in the investigation of the claim or any of the claim decisions. So, these types of claims are out there on most coverage actions we see. You need to be aware of them and take them seriously, but I would say that the vast majority that come across their desks do not have merit, but they do have to be dealt with.
Well, thank you very much, Steve, for summarising a lot of information so clearly. Well, that concludes our presentations. It's been a bit longer than usual, but we still have time for 2 or 3 or 4 questions if we have any, Harriet.
We do indeed. On the back of that mammoth exercise about punitive damages, I'm not sure whether I'm happy practicing in the UK or the USA, but however, do you have any tips, Steve, you would give insurers that insure risks in the US at the moment?
Tips. I would say when you find yourself in coverage litigation in the States and say you don't have a choice of law provision or a mandatory arbitration provision, critical to understand the local jurisdiction and to have good local counsel that's knowledgeable of the bar and the judges and the jury pool, the respective jurisdictions. Our practice takes us around the United States, and we'll often appear pro hoc vice as a visiting attorney in different jurisdictions. When we do this, we always try to associate with a local counsel that gives us that local knowledge of the courts that may not be apparent simply by reviewing judicial decisions. I think that's absolutely critical when you're litigating in the States, because you don't want to walk into, for example, you don't want to walk into a small Texas or Arkansas courthouse with an elected judge from the community and be viewed as the city lawyer from the East Coast. You need that local knowledge to really understand the situation that you're walking into, and if the claims are as they often are large and complicated, you want to have as much understanding of the venue you're in as possible.
So it's good for us to know each other then, basically.
Very true.
And staying on that point for a moment, Andrew, do you think it's fair that English courts don't award punitive damages?
Well, I suppose that depends on your point of view. We don't have punitive damages here. Punitive damages do keep insurers on their toes, no doubt, in the States. But on the other hand, punitive damage verdicts have to be paid for, and ultimately they're paid for by other policyholders. So, pushing out the price of insurance for everybody is something that the Law Commission did look at here some years ago. When thinking of reforming insurance law, they consulted quite widely, and unsurprisingly, people on the broker insured side advocated for a punitive damages system to be put in place, and the insurers resisted that. In the end, the Law Commission took this middle road, which is how we've got this provision I mentioned earlier on, where there's this implied term into an insurance contract that insurers should pay claims within a reasonable time. But I think the key difference between here and we're going to see how that plays out. But I mean, the difference is here is that damages for breach of that term are going to only be compensatory, not punitive. So do I think it's fair? Well, okay, I'm going to sit on the fence and say I think the Law Commission probably got the balance right over here.
Well, what they say is that what starts across the pond generally comes our way eventually. So let's see if you're right or not. We've just time for one more question, Steve, if I may. Would you say the US is a dangerous place to write insurance business? Fascinating question.
Yeah, I mean, so the U.S. can be an expensive and time-consuming place to litigate an insurance dispute, but it's also such a large country, and there's such variation amongst the jurisdictions as we discussed that I think it would be painting with a broad brush to say that it's on whole a dangerous place to write insurance. I mean, for example, you have states like Connecticut, New York, both have large insurer presence. I don't think either is a bad jurisdiction for insurers. You also have, on the other hand, jurisdictions like Florida and Washington State that historically have been more challenging, although there's some signs that Florida may be improving. Yeah, again, I think you need to understand where you're writing. And when you end up in coverage disputes, assuming you don't have an enforceable choice of law provision or a London arbitration provision, you need to really understand the nuances of that jurisdiction that you're dealing with.
Thank you very much. We could go on forever, but I'm afraid we really have now run out of time. So Andrew, if I may pass the baton back to you to close up.
Thank you. So just a quick mention of our next session, which is on the Financial Conduct Authority's new consumer duty, which will be on the 15th of June, presented by Rachel McDonnell, a partner in our commercial disputes team, and Claire Roke, principal associate in our insurance disputes team. Relevant to anyone underwriting business in the UK, because the new rules come into force on the 31st of July 2023. We look forward to seeing you then. Details will no doubt be sent to you in due course. But just to wrap up, thank you all for your kind attention today. And thank you very much, Steve, for co-presenting with me today and getting up so early. If you have any questions about this, and I can see there's a couple that we haven't been able to get to, which we'll get to afterwards, please contact Steve Clancy or myself directly. We'll send out some feedback forms after this. Please do fill them in. We do like your feedback and ideas. But that concludes today's session. Thank you very much, everyone.
Thank you.